I start with the very obvious question. What's the fuss about the seats? What is the big deal about the seats? This thing. A seat's not just a place for us to sit down, get on with the hearing, and then move on. What's the big deal about the seats to warrant this kind of discussion? Now, the answer, as Professor Donegate taught us in law school, is it depends. There's a distinction between seats, place, venue, and all the other terminologies. Now, let me start with the seats, because all these terminologies have different legal connotations. They have different implications. Gary Bond said the arbitral seat is the nation where an arbitral or where an arbitration has its legal domicile. In other words, once you choose a seat, the arbitration law of the seat defines the procedural framework for that arbitration. Now, so for example, if you choose a seat for Nigeria, by default, the AMA 23 will be the applicable procedural law. Furthermore, the concept of the seat implies that it is the local courts that will have complete control in terms of judicial remedies, interim remedies, subpoena, and so on and so forth. Again, by Article 5(1)(e) of the New York Convention, the seat is the country in which the award was made, and it's only the courts of that country that can set aside or annul the award. So those three basic things. Number one, once you say you have a seat, it is the procedural law of that country that will govern the proceedings. Number two, it is the local courts that will grant judicial remedies to support. And number three, it is the courts, only the court of the seats that can annihilate or set aside. Now, what about place? Some people use the word place or venue. And place simply means the physical location of hearings and should not be confused with the seat. Now, where the conflation came in is, today, we see many arbitration clauses, even now, that you just say the place of the arbitration shall be XYZ. Now, is it the same thing? Is it just a mere matter of terminology? What is the big problem with it? Now, again, it depends. The place, use of that term place, was imported by the old ACA, Section 16. And I would implore your patience. Let me quickly read Section 16. You see the problem there. 16.1 and 16.2 of the old Arbitration and Conciliation Act. 16.1 says, unless otherwise agreed by the parties, the place of the arbitration proceedings shall be determined by the tribunal, having regard to the circumstances of the case. 16.2 now said, notwithstanding the provisions of subsection 1, unless otherwise agreed by the parties, the tribunal shall meet at any place where it considers appropriate for consultation, for hearing of witnesses, of experts, for inspection of documents, and so on and so forth. So we see the place used twice, and obviously in two different contexts. And that issue came up for judicial determination in NFPC and looting. And the Supreme Court had to clarify that although they used the place twice, they meant two separate contextual settings. And then it now said subsection 1 has to deal with where the arbitration will take place. Subsection 2 has to do with where the tribunal may meet for the purpose of hearing evidence. So we can say, okay, all well and done. So that's settled. Unfortunately not. There is a particular case that now highlighted the problem with using place and not defining seat. And that case is the case of Zenith Global Bank Limited versus Zongfu International Investment. I only take the part that has to do with this. Now, in that particular case, the parties did not make any express provision in their agreement as to seats. The only thing that was in the arbitration clause is that they said the place of the arbitration shall be in Singapore. Now, they are Nigerian entities, and one of them started arbitration in Singapore. The other party filed an application before the courts here in Nigeria, asking for an anti-arbitration injunction to restrain the arbitration taking place in Singapore. So the question now is, does the Nigerian court have jurisdiction to restrain arbitration taking place in Singapore? Now, the judge, Akinyemi J, analyzed the case and he came up with 4 pointers. And he said, number one, the parties were all Nigerian companies. Even the Chinese company was established here in Nigeria. Number two, the substantive contract is performed in Ogun State, not Singapore. Number three, the applicable law of the contract is Nigerian law. Number four, any award from the arbitration will be enforced here in Nigeria. So the judge concluded that Nigeria has a closer and more intimate connection with the arbitration in Singapore, and that the seat of that arbitration should be Nigeria and the place will be Singapore. If the seat is Nigeria, then the judge has the power to restrain the arbitration taking place in Singapore. On that basis, the judge assumed jurisdiction and then granted that order, restrain the arbitration in Singapore. So that is the inherent problem if you just use the word place. Your seat, it will lead to unintended consequences that any court can construe seat for you. And before you know it, the court you don't want to intervene will intervene. Now, at any event, Section 32 of the AMA, our new law, has now tried to define seats properly now. Now, for about 2 minutes, let me quickly look at what we call the delocalized theory. Don't worry. Delocalized, delocalized, delocalized theory, which was propounded by the late Professor Gaya. Now, the localized theory of international arbitration runs completely against seats. They don't believe in seats. In summary, delocalization involves freeing the arbitration proceedings from the constraints of the seats. So it frees the arbitration from applying the lex loci, which is the procedural law. It makes the proceedings to float free from any national jurisdiction. So you can, for example, have it here in Nigeria or somewhere, but any resultant award will not be called a Nigerian award, and the Nigerian court may not have supportive jurisdiction. Now, it was reasoned that if an international arbitration award is not anchored or tied to any particular proceeding or to any particular jurisdiction, there is a decision of international justice whose validity can only be ascertained according to the general norms of international justice. More or less, they want to create a parallel world court. And some countries actually apply that. And it actually stems from the principle of party autonomy, that parties are free to determine how their dispute will go without the dispute being subject to the mandatory norms of the seats. So in a nutshell, that is what Order 1 says. It simply seeks to free the arbitration from applying your lex loci. It frees them from any mandatory norms of the seat. So they are just borrowing your country. They are free to apply any rules they want. They are free to ignore any mandatory norms. So for example, you want to go to Saudi Arabia does not believe in interest. So if Saudi, for example, now accepts this delocalized theory, that means any tribunal can go and sit there and start awarding interest. Now, again, very important. It means if an arbitral award, and you need to pay attention to this, if an arbitral award is set aside, it can be set aside in any other place, not being the courts of the seat. Remember, the New York Convention says it's only the court of the seats that can set aside an award. Any other court can only refuse recognition. But if your jurisdiction is practicing delocalized theory, then it means that any court anywhere can just set aside the award, even though it is not the court or the seat. My short comment is that while some countries permit that, Switzerland permits that, France permits that, do we want to adopt that in Nigeria? My answer for now, tentative, is maybe not. At any event, our national arbitration policy that we talk about says firmly that any arbitration against any government entity shall have the seats in Nigeria, meaning we don't believe in that. I will conclude by coming back to the issue of the seats. So we've agreed that Nigeria practices seats. Any arbitration in Nigeria is subject to the mandatory norms in Nigeria. And I want to zero in on the issue of a foreign seated award. Does Nigerian courts, being the courts of a jurisdiction, do we have the power to set aside a foreign seated arbitration? Nigerian law is presently in a state of flux with regard to this question. There are two competing decisions of the Court of Appeal. I'll quickly discuss it and I will close. The first decision is highly controversial, Limac and Sahelian. In Limac and Sahelian 2021 Law Pavilion, and please pay attention to that date, that decision was handed down in 2021. A Nigerian court had to deal with an ICC arbitration award. The award was seated in Switzerland, and the award was sought to be enforced here in Nigeria. The award debtor went to the Federal High Court and asked the Federal High Court to set aside the award. Remember, it's a Geneva, Switzerland award. And then the issue that was raised by the other party is that that award violates some mandatory provisions of NOTA, meaning that the subject matter was not registered with NOTA. So therefore, the argument is against the public policy of Nigeria to enforce the award. On that basis, the court set aside the award. They went to the Court of Appeal. Now, at the Court of Appeal, in a very sweeping judgment, Court of Appeal left aside the arguing part well of public policy. Because in my own view, I think probably the trial court made the right, but on the issue of public policy. And what it should have done is to refuse to recognize. But what did the Court of Appeal say? Court of Appeal said the Court of Appeal left aside all the public policy arguments. They said Nigerian courts are expressly conferred with power, with jurisdiction to set aside an arbitral award made outside Nigeria, irrespective of the country that it is coming from. Now, that decision was handed down in 2021. Let's put that in the cooler for just a few seconds. The second case, Oil and Industrial Services and MPEL, 2025 decision, handed down this January. There was an application to enforce a LCIA award, London Court of International Arbitration. LCIA award seated in London. We brought it here to Nigeria, wanted to enforce. Filed the application to enforce. The other party filed an application to set aside. And it was argued. The setting aside is on the basis of arbitrator misconduct. We argued that case. I was able to tell the judge that, my lord, you don't have the jurisdiction to set aside a foreign seated award. The judge accepted the argument, declined jurisdiction. The case went on appeal to the Court of Appeal. All the papers were filed, and it was when we were preparing for the hearing that we became aware of Limac. So Limac was not in all the briefs, and Limac now supports what the other party is saying. Limac is saying that a Nigerian court has the power. So in the run-up to the hearing, I had lengthy conversation with Dr. Ajibade, because I was the one that went to argue it. Now, what do? Should we draw the court's attention to LIMAC? And LIMAC is squarely against us. We now said, you know what? Is it the best ethics of the profession that even though there's a decision against you, bring it to the attention of the judge and then canvass the reason why, which was what we did. So a week before, we filed list of other authorities, brought out the case, and then filed some other cases, including Abacha and Fawemi. Abacha and Fawemi says where there is a conflict between two statutes, particularly there is a foreign domesticated statute, the court should have more regard to the foreign treaty, that it has a superior flavor to the Nigerian one. Why did we go down that route? Because in LIMAC was anchored on Section 48 of the ACA. Meanwhile, we are anchoring our argument on the New York Convention. New York Convention says only the court of the seat. And the New York Convention is domesticated into the ACA. So the two provisions contradictory are in the ACA. So our argument before the court is that although the two of them seem to be a bit contradictory, the court should lean in favor of the New York Convention, which is of a superior flavor to what Section 48 is saying. Thank God we came prepared for that argument. When I appeared before the Court of Appeal, lo and behold, one of the justices that wrote LIMAC is the presiding judge. Waiting for me, thank you. So there are three of them, of course. So when I raised it, so Motu, my Lord, we filed new authorities. This goes against us. One of the judges looked at me. I said, you this boy, what is wrong with you? Why are you bringing something that is against you? But I had to show that this is the problem. LIMAC is a new authority. LIMAC came up after we filed our brief of argument. And based on all the arguments canvassed, we invited the courts to depart from LIMAC, even though one of them is the presiding justice, and uphold our argument in OIS. 2 minutes. Thank you. So the judgment came out January this year. Guess what they did? The court simply said, the court completely ignored all the arguments. The judge said, we've looked at a decision. We believe that the lower court was right to decline jurisdiction. Full stop. They did not want to say, so that case was a missed opportunity to correct LIMAC. The presiding judge wrote the judgment. I would then forward this to the secretariat who circulate it. That person wrote, the presiding judge wrote LIMAC, and did not want to say that I've seen superior arguments, I'm wrong. So the judge just took the easy way out to say, I hereby endorse what the lower court said. The Nigerian courts lacked jurisdiction to set aside the foreign arbitral award without any analysis. So in conclusion, what we now have is two judgments. But I will argue, and I will submit to say, even going by the dates, since the MPL one is 2025, it has to be preferred. And again, whether or not there was an analysis, at least the person that wrote one of the concurrent, or what do you call it, the concurrent judgment actually was brave enough to make that statement to say a Nigerian court should not set aside a foreign seated arbitration. Thank you very much for your time. I'm grateful to you.
The decision of the lower.
Yes.
So that is the position of the appellate court, whether they said it expressly or not, which is contrary to
LIMAC.
But I would respectfully think that you have to complete the decisions of the court of appeal on this issue at this point.
Yes.
Any of the courts can decide which of them
to follow.
So that is a challenge. And I think at some point perhaps it would be wise to go upstairs to have the Supreme Court have a look at it and finally to have it resolved. It's still an open question.
Well, yes. Well, The other side has actually appealed now. No. Well, not cross appeal, because we agree with judgment. But what we want to file, once they serve their brief, is to file a respondent notice to support that judgment and to ask the Supreme Court to uphold it on the other grounds of appeal, to say that what they said was right, but this is the proper analysis that should be made. And to now invite the Supreme Court to expressly say that LIMAC is a wrong decision, because the lower court lacked that bravery, so to say, to confront his own decision and say that they were wrong. Thank you.
Thank you very much. Now, raise your hands or forever hold your peace. Okay, so we have Mr. Member my Mr. Oh, we have online questions. Okay, and we have Chief Power. I will let Mr. Major go first. I don't say the big masquerade that comes last. So we'll let the Chief Masquerade come after, and we'll let the YMG go first. You're welcome, Chief Power. Our second vice who has just come in. You're welcome. Thank you very much. Yes, please.
Thank you very much. Thank you, Dr. Mayomi. I find this delocalization theory very interesting. This is the first time I'm hearing about it. And my comment is actually that parties may unwittingly now, by applying that theory, actually remove that of party autonomy that they think is what it supports. And I'll give an instance of what I mean. So give an instance where, an arbitration that is seated in New York is based on the procurement of guns, ammunition, right? And that is what that award is given. And then say Nigeria, obviously we know the arbitration policy does not allow that, but let's say Nigeria were to adopt that theory.
Yes.
The one party then comes to Nigeria and says that, oh, our public policy does not allow for procurement of ammunition.
Yes.
And so set it aside. In that instance, in applying the delocalization theory, you have unwittingly now even said that what arbitration that you had said should be able to determine your dispute regarding the procurement of your guns.
Yes.
You've now gone to another place to now say that no, you cannot even use arbitration to settle this kind of dispute. And so I would lean, I agree with you, I would lean against this adoption of this delocalization. I think that it actually works against party autonomy. Yeah. And we all know that any recalcitrant respondent, so I'm not talking about when there are real grounds to, go against an award. But most times when there's an award letter, the first thing they want to do is for any flimsy reason to set aside. And if you give them that, they'll just go to forum shopping and just go to anywhere that supports what they want to do. So I think we should be very wary of that. Thank you.
Precisely. That is a major problem with applying the delocalized theory. Because inevitably, it leads to forum shopping, looking for a favorable jurisdiction where you can set aside on any flimsy ground, rather than sticking to the courts of the seat. And that's why the seats principles is attractive. Because before you put it in your arbitration clause, you have looked for an attractive seat for the award. Even though you can even say that the seat will be maybe England, because you know that England rarely set aside award. And I can say that the hearing will be held in Geneva. So go to Geneva, enjoy your time there. But when it comes to setting aside, you are bound to British law. So that is the real problem there. And thank you very much for supporting that.
I was listening to the matrices of judicialists. How the courts to stick to principles, how respondents' notice should be taken out by the other side to succumb to decision on that grounds. Our courts have held that acts of the National Assembly
be rendered void, not by the Constitution, but by reference to other acts of Constitution. That should surprise everyone. We're not the British Parliament, where the Parliament supreme parliamentary laws and acts of supreme law. Here, a Constitution is supreme. And all other laws take validity references to the supreme law. The only rule that an act of the National Assembly can be void by reference to another act. They say a last act of the National Assembly can be void by reference to an earlier act. Yeah, that's what they said it is. So, a court as transactional. That is unfortunately the times that we find ourselves in. And also, barristers who are again an urgent position for the courts, such matters have to be very aggressive.
Yeah.
Not aggressive to the point of fighting the judge, aggressive to the point of putting your face. And do that without removing your shirts and wearing gloves. Sometimes the judges don't vote. Sometimes they know they just bring the attention. So that's my advice. And I also want to use the opportunity to greet everybody here to thank you for allowing me to speak. I think my car was she's my daughter, she's only a mom.
Thank you very much, sir, for your very kind words. But indeed, that was what played out on the day of the hearing. Was like I said, you were the one that discovered the authority. And when I first showed it to the court said, this case is obviously against you. So it took a bit of intricate persuasion without fighting with the court to show that although this decision is against us, but if you apply Abacha and Fawemi that says a domesticated treaty enjoys higher superior flavor, and then J. Brawal, about 5, 6, by the time I was going through all the cases, one by about 6 of them, they had cause to change their mind and say, there is something there. I agree with your point. Thank you very much.
Very much for that. Yeah. The question I wanted to ask was actually flowed from the answer you gave to the question concerning the localized theory. So this localized theory is one of the universal application for local to Nigeria. And then secondly, sorry, 15 more seconds. About what Chief someone said and what you said as well. The problem again in trying to push an argument before the court, and even the Supreme Court, that they just wanted to adopt, in most instances, they try to come and adopt. In the days of yore, you really argue the point you wanted them to depart from or to go, and we're allowed to speak. I think for 15 minutes, but now they don't say adopt your view. So to give you have your work cut out, even try to urge the different position of the court now. It's not already in the view. So we just pray that this gets better. Amen.
Thank you very much. Thank you very, very much.
Sorry, Madam Chair, just 10 seconds. I mean,
Localized.
yeah, just the so the localized theory is practiced in some countries with the sole aim of attracting arbitration.
So that was Professor
Gaya.
That's how
Yeah. So Professor Gaya, if you know him, was someone that was pushing for the attraction of France. And Professor Gaya was France, Paris, as an attract. Professor, no, Professor Emmanuel Gaya. Well, no. Gaya is spelled Galade, Gillarg. Yeah. No, for him himself, that's the way that the man pronounces himself. The name is like no. So what he said and what some religions are now practicing is a school of thought to try and make some countries to be arbitration friendly, to bring people in that if you come in with your proceedings, we are not tying you to our mandatory norms. Come and do it any way you want to do it and leave. And that's why, if you look at statistics, Paris and Geneva are actually leading appearance centers, but they don't tie the arbitrations to any of their national mandatory norms. But do you want to do that in Nigeria? I doubt it.
Thank you very much, Dr. Mayomi. Thank you very much. I know that spend another 30 minutes. There's so much that we will do.